Hi, this is Fred Neiman of Hanlon Neiman, a central New Jersey law firm practicing Medicaid law in all 21 counties of the state. Will you be able to obtain Medicaid if you make a gift within 5 years of the date of filing your application? The short answer is yes, but you will likely be penalized. New Jersey has a law which says that if you apply for Medicaid, but you've made gifts within 5 years of the date applying, then the County Board of Social Services can penalize you dollar for dollar for the value of that gift. And that gift will be served by what is known as a penalty period. In other words, the County Board of Social Services will review your application, will total up all the gifts made within 5 years, and based on a formula that I need not go into detail for purposes of this video, will impose a time period by which they will not pay the nursing home or assisted living or your home-based caregivers Medicaid benefits until the penalty period is served. New Jersey says that if you want Medicaid, but if you've gifted within 5 years, then you can't be given the full value of the Medicaid services without first serving a penalty period. That penalty period is intended to discourage family members from making large gifts in order to impoverish themselves and to then be immediately eligible for Medicaid. So when families come in and I ask them, have there been any gifts? Depending on the circumstances, I'll tell them that if the gifts are large enough, it is likely that we will be penalized for a matter of days, weeks, months, or even years, depending on the amount of the gift. Let me give you an example of where this becomes really unfair. Let's assume mom or dad was healthy 3-4 years ago. Let's assume they made a gift to you of $5, $10, $15, $50,000. They were healthy when they made the gift. A year later, mom and dad come down with dementia, and it's very aggressive. Or they have a stroke or some other catastrophic setback, and now they have to apply for Medicaid. Unless you can demonstrate that when the gift was made, it was not intended to qualify for Medicaid, you will be penalized. But if you can demonstrate that at the time the gift was made, your parent or loved one was in good health, lived a vigorous, active lifestyle, had no intention of filing for Medicaid, but an intervening medical event caused them to now require long-term care benefits, and they've otherwise spent down their resources, the law does allow you to file for an appeal and claim hardship and explain that the transfer wasn't made for purposes of Medicaid, but rather out of love and affection or for purposes of state plan. It's a very nuanced area of the law. It's something that oftentimes the county boards of social services don't recognize. They'll tell you carte blanche, any gift equals penalty or denial. I'm here to tell you that they're generally right, but not always. There are some circumstances. So if gifting is a prospective issue in your Medicaid application, you need to come in and talk to me. Let's discuss it. Let's see whether in fact there's a way for us to avoid that penalty and try to get your parents qualified immediately.